So welcome to CPD4Me. We provide practical and relevant training for busy professionals. My name is Bronwyn Pott, and today we've got a substantive law update. We work in a pretty fast-moving and changing environment, and that includes the laws that we work within. Our aim is to bring you recent case studies, precedents, as well as updates so that you're able to stay on top of your game.
We're going to start today by looking at a few different types of exclusions and insuring clauses contained within public liability and professional indemnity policies, then have a look at some basic construction principles surrounding the interpretation of policies, and in particular to look at what are professional services within the insuring clause of a policy or as contained within an exclusion. Then we're going to have a look at 5 cases which have each considered the interpretation of the meaning of professional services within various types of policy wordings. So this definition really relates more to the older styles of profession, such as doctors, lawyers, and those which were predominantly mental or intellectual. But there has been an increasing trend towards insurance of professionals engaged in manual or physical labour. And the important point that Justice Derrington makes is not to focus on the fact that a lawyer is being sued, but rather on the facts underneath it, namely to consider closely the nature of the conduct under scrutiny rather than the title or position of those involved or on the form of the pleadings. And secondly, that the title or character of the party performing the activity or the general job description is not determinative. Rather, as Justice Derrington suggested, it's important to look behind the technical form of the pleadings and look at the precise conduct which is likely to give rise to a liability for the insured. And this brings us to the first case which we're going to consider today, namely the often misquoted and misrelied upon decision of the New South Wales Court of Appeal in the 1996 decision of GIO General Limited v Newcastle City Council. So the next case, Major Engineering Proprietary Limited and CGU Insurance, involves a different perspective on the professional services question, namely whether or not a professional services exclusion applies in the circumstances of a given claim.
I hope you enjoyed this session today from CPD4Me. Continuing professional development should be about learning new things, about challenging yourself to learn and grow, about finding better ways to do the things that you do every day.